Welcome to this installment of Clarifying Tax Situations with attorney and CPA David W. Klossing.
How do community property and separate property rules affect a divorce? In the United States, there are currently 9 community property states. These include Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. In its most simplistic form, community property is a state statute that mandates concurrent form of ownership between husband and wife. In community property states, the earnings of the husband and wife are considered community property and thus are equally divided between the spouses during marriage. Any assets that are purchased during marriage with community property funds remain community property marital assets. Separate property can consist of property that was acquired before marriage, property that's inherited during marriage, or property that's received via gift during marriage. Separate property of each spouse, even where it's brought into a community property state, remains separate property, provided that the property is kept segregated, i.e. it's not commingled with community property assets, and thus is separately identifiable. Any income generated by a separate property asset is separate property income and belongs to the spouse that owns the separate property. Under California Family Code 125, California, during a California divorce, can treat property that is acquired in a common law state as community property if the property would have been considered community property had it been acquired in California instead of out of state. Separate property in California also includes where separate property is sold and new property is acquired. If the proceeds are traceable to the sale of separate property and that asset isn't commingled with a community property asset, it remains separate property. Any property that is inherited during marriage is separate property, but if it's commingled with a community property asset, it may lose its distinction as separate property and become community property in situations where it's not separately identifiable. In California, it's important to think about the fact that separate property can be improved with either community property assets or community property labor. Where this occurs, it may be necessary for an allocation of value to be given back to the community property estate before it is split in a divorce. Where this comes up a lot is where a separate property business is owned before marriage. Even though the business is a separate property business, one spouse owned the entire business before they got married. The entire time that they are improving the value of that business through their own labor, that labor is a community property asset, and the marital estate is due an allocation of value for the improvement in that business over the course of the marriage. Again, the labor of a spouse that improves the value of a business during marriage is a community property asset. For this reason, if a business predates a marriage, it is very likely that this will require both a separate property allocation of value and a community property allocation of value. The allocation between separate property and community property value depends on several factors. The factors considered to make this allocation include the following. How long before marriage was the business started? What was the company's fair market value at marriage and its history of profitability before and up to marriage? What was the business's average cash flow both before marriage and during marriage? Here's the really tricky one. Of the increase in value during marriage, how much of that can be attributed to the community property efforts of one spouse versus the separate property value that was contributed at the beginning of the marriage? Was there additional separate property invested in the business during marriage? Was there additional community property income that was invested during the marriage? What were the market conditions, both when they got married, over the course of the marriage, and at divorce? Community property laws may be relevant even in common law states. For instance, if property is acquired in a community property state and then later taken into a common law state, it retains its character as community property for both divorce purposes in the common law state and for income tax purposes.